today we're going to be discussing temporary restraining orders, preliminary injunctions, and PAGA, better known as the California Labor Code Private Attorneys General Act.
Good morning, everybody, and thanks for attending. This is us. Okay, so I wanted to talk today, give a bit of an overview on the claims that typically referred to as PAGA, California Private Attorneys General Act. These are becoming increasingly popular in employment cases, and I think by the end of my overview, hopefully you will understand why. So it's a very advantageous to employees and plaintiffs' lawyers to add this claim onto other claims against employers, and also we're seeing a big increase in what we're calling PAGA only claims. So instead of seeking remedies for direct violations and then adding on this PAGA claim, we're seeing a lot of actions coming just with this PAGA claim. So, and let me tell you a little bit more about what it is. So this is a statute that has authorized employees to file lawsuits in place of the state to recover penalties that the state itself was only able to recover before. So it allows one employee to seek penalties for alleged violations on behalf of themselves, other employees during the time period, and the state of California. Essentially, this is permitting what I call a representative suit. So you can include all employees who might have suffered a violation without having to meet the typical class action requirements. Much lower bar to meet, much easier to proceed. There is, as a note here, the penalties that are recoverable are only those that were previously recoverable by the state. So this does not apply to penalties recoverable directly by employees. For example, under the Labor Code, employees can directly sue their employers for waiting time penalties, pay stub penalties, meal and rest break penalties. These are not penalties that can be recovered under PAGA, but the catch is that the violation of some of these acts or the similar acts will create penalties that were recoverable by the state that now individuals can recover. So, and the way that this came about, the legislature decided to enact this because the Labor and Workforce Development Agency and its departments and divisions were unable to prosecute employers for these labor code violations, so they handed it over to the public. And the public has, it's really been increasing, as I mentioned, in several years and becoming a very common claim. One thing is, though, that it's still being worked out. There's a lot of questions about almost every aspect of how this works. It's being litigated and there are not a lot of clear answers. The penalties that the employees can receive are split. 25% of the penalties that are received go to the aggrieved employees, and 75% go to the LWDA for education and enforcement purposes. When there's more than one aggrieved employee, then the 25% that goes to the employees has to be distributed among all of them. So it's not just to the named plaintiff or the named party bringing the action. It has to go to all of the aggrieved employees, similar to a class action. Now, the penalty amount that you can recover is either the statutory amount, the amount that's specified in the statute for the violation you're seeking damages for, or PAGA imposes its own penalties for any labor code that does not have a specified remedy amount. And that is $100 per initial violation per pay period and $200 for each subsequent penalty. So for example, if you have a inaccurate wage statement, doesn't meet all the requirements of the essentials that you need to include as an employer, these penalties can add up really quick. So $100 $100, especially if you're paying weekly. If you just think about it, in a month, one person would be entitled to $100 for the initial pay period violation, and then $200 for each subsequent penalty, which would be $700 for 1 month for one employee. Difference between regular claims for labor code violations, and it's that PAGA allows plaintiffs to seek individual liability against individuals other than the corporate employer. So typically, unless it's harassment or something like that, your direct supervisor is not liable for inaccurate wage statements or any of these violations, not being able to have suitable seating. They're not personally liable, but under PAGA, there is an avenue to do that. There's been some cases where the owners, presidents, secretaries, and directors have been held liable for these penalties as well, for overtime and wage violations. So that's obviously troubling for employers. The other big thing is that arbitration agreements in California cannot waive a plaintiff's right to bring a PAGA representative action. So employers often have an arbitration clause in their handbooks, or when they start employment, at the beginning of employment with their employees, and seek to agree to have all conflicts arising out of employment from either side subject to arbitration, and if possible to waive any class actions or collective actions, meaning that the employer and the individual employee can bring actions in arbitration only on behalf of themselves. So it eliminates the ability to do a class action, but that does not apply to PAGA actions. And the reasoning so far is that the plaintiff is standing in the position of the LWDA, and the LWDA is not a party to those arbitration agreements and cannot waive its right to bring an action for penalties against the employer. So often PAGA claims will be added onto class actions. The PAGA claims cannot go to arbitration and will proceed still under state litigation or whichever court it was filed in. So kind of in summary, these are some of the big reasons already that it becomes more popular for employees and plaintiffs' counsel to bring these actions, because the penalties add up very quickly. They can bring essentially a representative or class action without having to meet any of the class action requirements. They can seek liability against other persons they were not able to under labor code violations. It can't be pushed to arbitration. I mean, basically, those are all big advantages for a plaintiff. In order to have standing as a PAGA plaintiff, you only need to be currently or previously employed by the alleged violator of the labor code and suffered one or more labor code violations. And to be clear, this means that PAGA plaintiffs do not have to experience the same violations as the other aggrieved employees in the representative action. So essentially, I could say, I am owed some overtime, and so I'm going to bring a PAGA action on behalf of other aggrieved employees for some overtime pay and anything else they may have suffered. For example, Jane didn't get suitable seating, and all of this department wasn't provided seating, and this department's wage statements are wrong, and this department's meal and rest breaks entitle it to a penalty. And it doesn't matter that none of those apply to me. As long as I have suffered one violation, I can bring the action for all violations of all employees during the time period against that employer. And the one benefit is that the statute of limitations is 1 year. So that does help, but the problem is that you can also get these PAGA actions stacked one on top of each other, plaintiffs bringing a PAGA action for 2017, for 2018, for 2019, assuming they have met the administrative requirements. In fact, even if a plaintiff has settled his or her individual claims, he or she may still have standing to bring a PAGA claim. And this was recently a holding of the California Supreme Court in Kim versus Raines. There is some possibility. Well, first, let me tell you. So this individual plaintiff settled their PAGA claims, settled all of their individual claims against the employer, including their PAGA claims, and then brought an action on behalf of aggrieved employees for the violations affecting those other employees. His have been resolved, but he still sought a representative action on behalf of the other employees. So obviously the argument was, hey, his claims are resolved. He has no standing. But that didn't hold as long as he still suffered a labor code violation, even though it had been resolved. And so he was still able to bring a PAGA action on behalf of other employees. Now, there is possibly a way to distinguish this case, which would be helpful, and is that his settlement agreement had a carve out for PAGA claims. So there may be a way to wrap that up a little neater and avoid this, but that's definitely something to be aware of. Also, the breadth of labor code violations that are addressed under this act are extensive. These are just a couple of examples. For example, violations relating to compensation, working hours, meal and rest period violations, suitable seating requirements, workplace safety violations, misclassification, inaccurate wage statements. Basically, it kind of feels like almost any labor and employment law has a penalty that can be enforced. And again, the penalties when you attribute it to the entire group of potential employees is vast. In order to bring a PAGA action, the plaintiff has to first provide written notice to the state online. There's a website online that you can submit the claim to now, and it must be sent to the employer by certified mail as well. It has to be in sufficient detail to enable the state and the employer to know the alleged violations against them and to enable them to investigate them. So what that's meant is that it must specify the specific labor code sections that they are alleging are violated, and they must set forth the facts and theories to support the alleged violation or violations. Deficient notice does not toll the statute of limitations. So you have the plaintiff has 1 year from the alleged violation to submit this notice to the state and the employer. Say they waited till the last day and their notice is deficient, they can't amend it and then go back and extend back to the time they were initially seeking to sue from. That will not extend the statute of limitations for them. So if you're writing a notice, you gotta be really sure that you're covering all the claims you want to do and putting in the basic facts that you need to cover all of the allegations and actions you may want to allege. And on the other side is the employer. You want to see what kind of deficiencies you can see in there, and it might be beneficial, depending on the case, not to point them out immediately, because and give the plaintiff an opportunity to fix them, but to take advantage of the fact that the notice is deficient and cuts off some of the statute of limitations and the time period for the claims. After the notice is submitted, the LWDA has 60 days to decide whether to investigate it, and they're supposed to provide written notice to the parties. If they don't, it's assumed that the LWDA has decided not to investigate it, and a plaintiff can proceed with filing litigation 65 days after they've submitted their notice to the state. If the LWDA does decide to investigate the claims itself, it has up to 180 days to issue a citation to the employer. So it has another 180 days with that includes some extensions that are possible to investigate the claims and issue a citation to the employer. The employer does have the opportunity to cure some of these violations. So they could see the notice, say, you know what, this is wrong. We have been doing this wrong. Let's fix it. And you can eliminate some claims like that. You can just stop them, right? Okay, well, we fixed the problem, so now you don't have a PAGA claim against us. And that's only for a small number of violations, unfortunately. Most of the violations do not allow this opportunity to cure. Some that do are misclassification of employees, failure to adopt an injury and illness prevention program, and some wage statement violations. For wage statement violations, you actually have to fix the wage statements going back 3 years if the errors exist. And you only have 33 days to cure as the employer. Then you have to provide written notice of the cure to the LWDA and the employee to attempt to stop that claim. And of course, the employee can object that the cure was sufficient and things like that. But that is a possibility and can be really advantageous if you only have those types of violations. Unfortunately, for the vast majority of the violations that can be brought under PAGA, there is no opportunity to cure. As I mentioned, one potential benefit is that the statute of limitations is short. So there's 1 year for a plaintiff to file their notice with the LWDA. With regard to other employment claims, there's typically a 3-year statute of limitations, and then plaintiffs add on this unfair business practices and competition clause, claim, which then extends the statute of limitations to 4 years. So it is smaller, but as I've mentioned, some plaintiffs will add, or employers could face PAGA actions year after year if the issue is not resolved. Like a class action, it is binding on all of the aggrieved employees for the same violations in the same time period. So that's beneficial. If you resolve this matter, you know that another aggrieved employee can't bring the same action for the same violations during the same time periods. If they happen to uncover a new violation, however, that's a different story, or it relates to a different time period. And again here, that the statute of limitations is a bit helpful to employers, because if there's not too much time for someone to go back and find a different violation. Typically the 1 year has flown by while this is in litigation. Also, the settlement must be reviewed and approved by the trial court. So they're supposed to review. Oh, and you also need to send it to the LWDA as well, the proposed settlement, so that they can review it and make sure that it's fair and that the penalties they think are fair going to the state. So I think that they were concerned that some of these settlements of these actions were essentially valuing the PAGA claims as extremely minimal to give more of the damages and the settlement amount to the plaintiff, the named plaintiffs, and the employees. So now they have to be reviewed and approved by the trial court before they are enforced. And so that is kind of my overview of these PAGA claims.